commerce. On what reasons study of organization is important? The study of organization is important for the following reasons. A. Organization pervade in all the important phases of human life. A man is born in an organization, hospitals and clinics. He is educated in an organization, schools, colleges. He works in an organization, office, factories and business. B. Knowledge of organization helps the manager to work effectively. C. Organization satisfies and sometimes frustrates if it is not well organized. What are the contents of partnership deed? The written agreement among the partners is called partnership deed. The contents of the partnership deed are: A. Name of the firm. B. Date of agreement and principal place of business. C. Names and addresses of all the partners. D. Nature of business proposed to be carried on by the firm. E. Duration of the partnership, if any. F. Amount of capital contributed by each partner. G. Amount of withdrawal of each partner. H. Profit sharing ratio. I. Salary payable to active partner or partners. J. Interest on capital and interest on drawings. How are directors appointed in a public limited company? First, directors are usually named in the articles. If the articles are silent, the signatories to the memorandum shall be deemed to be the first directors of the company. A. Appointment of directors by the company. Subsequent directors are elected by shareholders at the annual general meetings. If a company adopts the principle of retirement by rotation, 1/3 of the directors must retire by rotation. The retiring directors are eligible for reappointment. B. Appointment by board of directors. The board can appoint additional directors. They can fill up casual vacancy caused by death, resignation, etc. They can also appoint alternate director. If empowered by the articles, the board may appoint an alternate director during his absence for a period of not less than 3 months from the date in which the meetings of the board are ordinarily held. C. Appointment by third parties. If authorized by the articles, third parties such as vendor of the business, banking or financial institutions which have advanced loans to the companies can appoint their nominees on the board. D. Appointment by central government. The central government can also appoint directors on an order passed by the company law board or on the application of not less than 100 members of the company or of members holding 10% of the total voting power. Explain the different kinds of speculators. There are 4 types of speculators who are active on the stock exchange in India. They are known as bull, bear, stag and lame duck. Bull. A bull or tejiwala is an operator who expects a rise in prices of securities in the future. In anticipation of price rise, he makes purchase of shares at present and other securities with the intention to sell at higher prices in future. He is called bull because just like a bull tends to throw his victim up in the air, the bull speculator stimulates the price to rise. He is an optimistic speculator. Bear. A bear or mandiwala speculator expects prices to fall in future and sells securities at present with a view to purchase them at lower prices in future. A bear does not have securities at present but sells them in higher prices in anticipation that he will supply them by purchasing at lower prices in future. A bear usually presses its victim down to the ground. Similarly, the bear speculator tends to force down the prices of securities. A bear is pessimistic speculator. Stag. A stag is a cautious speculator in the stock exchange. He applies for shares in new companies and expects to sell them at a premium if he gets an allotment. He selects those companies whose shares are in more demand and are likely to carry a premium. He sells the shares before being called to pay the allotment money. He is also called a premium hunter. Lame duck. When a bear finds it difficult to fulfill his commitment, he is said to be struggling like a lame duck. A bear speculator contracts to sell securities at a later date. On the appointed time, he is not able to get the securities as the holders are not willing to part with them. In such situations, he feels concerned. Moreover, the buyer is not willing to carry over the transactions. What are the differences between public and private sector? Public sector, service motive with twin goal, achieve economic development with the democratic values and economic equality. Private sector, profit motive, maximize the profits. Public sector, sufficient unlimited resources, successful in mobilizing savings through banks, bonds, etc. from foreign the economic development. Private sector, limited resources. The private sector is not successful in mobilizing the resources of the country or countries for. Public sector checks concentration of economic power in the hands of few. Private sector leads to concentration of economic power in the hands of few individuals. Public sector develop those sectors which are neglected by the private sector. Private sector develop those industries or sector in which risk is less and returns is more. Public sector preserves national wealth. Private sector exploitation of natural resources like forests, mines, etc. for personal advantage. Public sector brings in balanced growth. It starts industries in backward area. Private sector do not establish industries in backward areas. Public sector, heavy, basic and defense industries are reserved for public sector. Private sector, consumer goods, industries, agriculture are in private. Public sector, consumer welfare is considered important. They are supplied goods and services at cheaper prices. Private sector, consumers are exploited. Public sector, model employer, solves unemployment problem to a great extent. Private sector, exploitation of employees, welfare of employees neglected. Public sector, the management of public sector industries are managed by civil servants. They lack efficiency or skill to run public enterprises on commercial lines. Private sector, technically qualification and experience of private owners is used for efficient management of private sector enterprises. State the meaning of supermarket and its features. This term is basically an Indian one, but it is derived from English expression supermarket. It refers to a type of large-scale retailing. The articles of daily use are sold in different departments without the help of salespersons. It is usually started as a joint stock company to earn profit. They are usually located only in cities and big towns. They must have large daily turnover to earn profit on their large capital outlay. In India, the first supermarket was started in New Delhi. Supermarkets have a dominant provision section with more varieties. Other sections relating to clothing, footwear, stationery, crockery and other household items are displayed with their prices. The prices are fixed. There is no bargaining. Door delivery of goods is also given. Sales are made only for cash. Nowadays, credit cards are also accepted. Features: A. It is a form of large scale retailing. B. There is a wide variety of goods made unavailable. C. The system of self-service is used. D. There is no need for salesmen in self-service section. E. The layout is in the form of different departments. F. Sales are on cash basis. G. Goods are sold after cleaning and packing. H. No adulteration is practiced. I. Correct weighments are used so that consumers are not cheated by short weighing. J. Scarce commodities are also supplied. What is Memorandum of Association? What are its contents? Memorandum of Association contains the fundamental conditions upon which alone the company is allowed to be incorporated. It defines the activities the company is permitted to undertake. Any act done which is outside the scope outlined in its memorandum is ultra vires the company and is not binding on it. Contents of the memorandum. A memorandum of association must contain the following clauses, namely: A. Name clause. In this clause, the name of a company is mentioned to establish identity. It is a symbol of its existence. Undesirable name to be avoided. It should not imitate another company's name. If it is a publicly limited company, it should end with the word limited. If it is a private limited company, it should end with the word private limited. B. Situation clause. The state in which a company has its registered office is to be stated here. Exact address is within the state need not be given in this clause. It determines the jurisdiction of the registrar of companies and of the court. C. Object clause. This is the most important clause as it states the activities of the company. The objects lay down the maximum permitted range of activities. A company has the power to carry on only those types of business which are included in this clause. Any action beyond the powers of the company has no legal effect. Liability clause. This clause states that the liability of members is limited. In the case of a company limited by guarantee, the amount each member undertakes to contribute in the event of winding up must also be mentioned. Capital clause. The amount of share capital with which the company is to be registered and its division into shares of fixed amount are also stated here. F. Association clause or subscription clause. At least 2 persons in the case of a private limited company and 7 in the case of public limited company must sign the memorandum and agree to take the number of shares shown against their names. State briefly the contents of Articles of Association. Articles of Association (AOA) is another important document as it contains the rules and regulations for its internal functioning of the company. Contents of the articles. The important contents of the articles are: 1. The extent to which regulations in Table A are to be excluded. 2. Adoption or expectation of preliminary contracts, if any. 3. Share capital, different class of shares, rights attached thereto, etc. 4. Allotment of shares, calls on shares. 5. Procedure relating to forfeiture of shares and their reissue. 6. Issue of share certificates and share warrants. 7. Rules regarding transfer of shares and transmission of shares. 8. Conversion of shares into stock. 9. The payment of underwriting commission on shares and debentures. 10. Alteration of share capital. 11. Qualification and remuneration of directors. 12. Borrowing powers of directors.